Okay. Hello sa inyo. Magandang gabi. So, saan tayo ngayon? Continue. Ano ba? Sa dito? Sige, discussion tayo ulit for contracts. Title 2, contracts. Natapos naman natin yung chapter 1 and 2 last time, no? Mahabang topic yun. Ito, dito tayo ngayon sa next topics natin, which is napakaikling lecture video lang naman to. Parang additional notes lang to, kahit di nyo nga panoorin tong lecture video eh. Kasi madali na lang tong chapter 3, 4, and 5. Maikli lang sila, diba? Tingnan yung book, no? Ang nipis ng discussion sa page na to for this, sa page na to, sa topics na to, sa book na to. So with that, let's start with our discussion. So dito tayo ngayon sa chapter 3, form of contracts, yeah? Pansin niyo, di ba, maikli na lang tong discussion na to. And yung discussion kasi natin for chapters 1 and 2, di ba? Mahaba kasi doon yung bulk, yung half bulk ng discussion for contracts. Yung next bulk of discussion for contract is yung pinaka importante sa kanya, yung defective contracts. Kasi sa defective contracts, guaranteed pagdating sa topic na contracts, dyan kukunin yung mga question for the board exam. Promise. So, of course, ngayon, in-depth discussion tayo kasi first time natin to. First time nyo tong ma-encounter sa review na yan. So, yun. So, yung defective contracts, pati yung natural obligations part ng book. Next lecture video na yun. So, since yun na yung last topic for this subject, ito na yung second to the last video natin for this loan obligation and contracts. So, chapter 3, form of contracts. So, Article 1356 provides that a contract shall be obligatory in whatever form they may have been entered into, provided all the essential requisites, yung consent, yung consent, cause, and COC, consent, object, and cause, yeah, for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. Kailangan i-follow. In such cases, the right of the party stated in the following article cannot be exercised. So, anong pinag-uusapan nito sa chapter 3 kay Article 1356? So, basically, ano itong form of a contract? Diba? Sabi dito, form of a contract refers to the manner in which a contract is executed or manifested. Whether that's orally, oral conversation lang kayo, or nagkaroon kayo ng sulatan, formal, yeah? In writing talaga, para sure bells, yeah? Klaro yung napag-usapan. So, ganyan yan. The contract may be oral, in writing, or a combination of both. But take note, when it comes to written contract, it must be absolute. Meaning lahat, nakasulat. All must be written. The agreements, the stipulations, dapat nakasulat yan para matawag na a contract in writing. Kasi otherwise, kahit na half oral, half in writing yan, it will still be treated in the eyes of the law as oral. Kasi nga, ang requirements sa contract in writing, lahat ng napag-usapan, all must be written. Yeah? So, classification of contracts according to form. Dalawa tayo meron. Informal or common contract and formal or solemn contract. Sa informal contract, ito yung typical, ito yung chill na contract. Bakit? Or that which may be entered into in whatever form provided all the essential requisites for their validity are present. Yung cause, yung consent, object, and cause, diba? Kasi yun lang naman yung, in simple terms, diba? Yun lang naman yung kailangang requisites when it comes to contracts para yung contract mo maging valid, na? Tawag natin dito mga consensual contracts, such as the contract of sale, diba? Pagbibili ka ng sa tindahan. Pagbibili ka sa tindahan, bibili ka sa suki mo. Di ba naman kailangan ng resibo, di ba? Mere transfer pa lang, di ba? Bayad ka, receive mo consideration, receive mo yung item, goods na. Ngayon, punta tayo sa second classification, yung formal or solemn. For which dito, kailangan na Bakit? Required na ng law na magkaroon ng required by law for its efficacy, for its effectivity to be in a certain specified form para maging effective siya. Para maging ma-enforce mo siya basically. So yan sa informal or common, goods chill lang. Walang problema. It's consensual. Mere consent. Goods na. Pagdating sa number 2, sa formal or solemn, sabi ng batas, teka muna kapatid, may kailangan tayong form, specified form, para yung contract mo enforceable, effective, yung efficacy. Now, as provided in 1356, diba? Rules regarding form of contracts in general, as we have said, contracts are binding and therefore enforceable reciprocally by the contracting parties, whatever may be the form in which the contract has been entered into, provided yung essential requisites, ulitin natin, consent, object, and cause, present para valid yung contract. Ganun kasimple. Yun yung general rule. Pero may exceptions tayo as provided by 1356 and Chapter 3 in general. Yung una, when the law requires that a contract be in some form to be valid. Pangalawa, when the law requires that a contract be in some form para maging enforceable to or proven in a certain way. Pangatlo, when the law requires that the contract be in some form for the convenience of the parties or for the purpose of affecting third persons. So as you can see, may tatlo tayong may tatlo tayong types para kailangan gawin. Para maging not to say para magawin, pero makailangan gawin. 'Di ba? Kasi yung una, magkakaiba tong tatlong to. Yung una, yung validity mismo yung tina-target. Yung validity mismo ng contract ang tina-target. Yung pangalawa, kung titingnan nyo, yung enforceability. Yung enforceability ng contract, yung tina-target. Yung obligatory force, di ba? Yung pangatlo, ang tina-target dito is yung convenience lang of the parties. Kaya yan sineparate sila. Kasi iba yung tina-target nila. Yung isa, yung validity. Yung pangalawa, yung enforceability. And pangatlo is yung convenience ng parties para hindi sila ma-hassle, kumbaga. So ito, binigyan naman tayo ng example dito, di ba? So to form for validity of contract, there are rare cases when the law requires that the contract be in certain way for their validity. For their validity. Yung una, ito, mahalaga to, donation of real property. Magdodonate ka ng lupa, magdodonate ka ng bahay, kapatid, lagay mo sa public instrument yan. Lagay mo sa public instrument yan para maging valid. Kaya sasabi ko sa inyo, itong magkagandahan sa law on obligation and contracts, it is applicable sa totoong buhay. Hindi lang sa profession nyo. Sa day-to-day lives nyo, applicable tong law on obligation and contracts. Pag magtatanong sa magulang mo, anak, paano to? Masasagot mo. Kasi nag-aral ka. Napagdaanan mo yung topic ng obligation and contracts and be privileged about that. Bakit? Kasi yung ibang courses, hindi nila ito dinadaanan. Bibihira lang ang courses na may law on obligation and contract sa kanilang college curriculum. An advantage to kasi applicable sa totoong buhay. Ganun kagandahan yan, di ba? So ito, donation of real properties, public instrument for it to be valid. Ito naman number 2, donation of personal property, the value of which exceeds 5,000 pesos. So, yung real property, no matter what amount, no matter what amount, kahit 1 piece of lupa lang yan, di ba? 1 square meter of land lang, lot lang yan. Doesn't matter because that is a real property. No matter the value, you must put it in a public instrument. Pero pag personal property naman, diba? Personal property, 5,000, exceeds 5,000, the donation and acceptance must be in writing. Kasi nga, as I have said before, sa donation, di ba? Ang donation, nagiging valid lang yan kapag may acceptance ni Donnie. Nagiging valid lang yan kapag may acceptance si Donnie. Ngayon, kapag 5,000 and below, yung amount ng personal property na donate, okay lang oral. Pero kapag yung donation, yung personal properties more than 5,000, then it must be in writing. for it to be valid. The donation and acceptance must be in writing to be valid. So, ganyan ang style, kapatid. Paano? May style dyan, kapatid, di ba? May shota ka. Niregaluhan mo ng, matano bubol? Nag-give ka sa kanya ng iPhone. Ang iPhone, nila yan. 7 digits yung value niyan. So, more than 5,000 for sure. Ngayon, nag-break kayo. Mababawi mo ba yung iPhone na yan? Pwede. Sabihin mo, ay, hindi nga valid yung ginawa kong donation sa'yo eh. Bakit? Hindi naman in writing ang ginawa natin eh. Nung dinonate ko yan sa'yo, pwede mo bawiin yung iPhone na yun. Kasi nga, it was not a valid donation. Bakit? Di mo na, wala lang. Din write nyo. Donation and acceptance must be in writing. Hindi naman. Applicable sa totoong buhay. Mababawi mo yung mga dinonate mo. Mga ginif mo sa shota mo na naging ex mo na, pwede mong bawiin as long as it is more than 5,000 peso. Diba? Dapat is. So, third, sale of land through an agent. So, yung authority ng agent, since involving to real property, so yung authority ng agent must be in writing. Otherwise, yung sale ng land would be void. Stipulation to pay interest must be in writing para makakubra ka ng interest. Because, as you have said, interest is very burdensome yan. So, in order to prove such payment of interest, such requirement of payment of interest, it must be in writing because the burden, di ba? Pahirap ang interest kasi. So, kailangan patunayan. Ang contract of partnership. Ngayon, generally kasi, ang contract of partnership, it can be made orally. Yan na, Yes, yung mga partnership, it can be made orally. Yung partnership ay yung business entity, hindi yung love life na yan. Partnership, yung business entity, yung sole prop, partnership, corporation, ganun. Ngayon, yung contract of partnership na yan, it can be made in writing man or orally. Generally. General rule yun. So, yung may mga exceptions tayo. If immovables are contributed, yung partner nag-contribute ng immovable property, then it must be in public instrument to which shall be attached a signed inventory of the immovable property contributed. Because the nature of the donation is, para rin siyang donation of real property kasi nag-contribute ka ng immovable. So, yan. Kailangan in writing with the inventory of the property. So, yan. Ngayon, ito, kung mapapansin nyo, ito, form of enforceability of contract. In the cases of contracts by statute of frauds, dito tayo sa statute of frauds tag dito? Kasi di ba napag-usapan natin yung una, yung when the law requires that a contract be in some form to be valid. Yun yung napag-usapan natin. Ngayon dito tayo ngayon sa when the law requires that a contract be in some form to be enforceable or proved in a certain way. Diba? Kasi tatlo yan. Napag-usapan natin yung sa validity. Diba? Yung yung donation of real property, donation of personal property with value exceeding 5,000 pesos, sale of land to an agent, stipulation to pay interest, and yung contract of partnership. Mga example yan ng contracts na kailangan in a certain form, yeah, in writing, public instrument, para maging valid. Yung second naman is yung kailangan for their enforceability. Or prove in a certain way. Ngayon dito sa enforceability or prove in a certain way, saan ito form? Pag-uusapan to pagdating sa unenforceable contracts. Sa unenforceable contracts, so kasi we're talking about enforceability. Ang unenforceable contract nasa defective contracts sa next lecture video yan siya. Pero pag po sa G's lang ng unenforceable contracts. So let's go to Article 1403 kasi doon yung pinag-usapan si unenforceable contracts. Pero basahin natin ang nakalagay dito. So, ang unenforceable contracts kasi, konting G's lang, is that it cannot be it is a valid contract. Diba? Nasabi natin, di ba, ang voidable, valid until annulled. Ang rescissible contracts, di ba? They are also valid until rescinded. valid yan sila until rescinded. Ang unenforceable contracts, yeah, ang definition niya, those that cannot be enforced in court or sued upon by reason of certain defects provided by law until and unless they are ratified according to law. Ito namang unenforceable contracts, valid din sila. These are valid contracts. However, the problem with them is that from the name itself, it is unenforceable by court. That's the problem. Hindi mo siya pwedeng ma-enforce because of that certain defect. Diba? Because of that certain defect. For example, yung una, both of the parties, they cannot give consent. Oo. Kasi 'di ba sa voidable contracts, isa lang. Yan, napag-usapan natin last time. Isang party lang yung hindi makabigay ng consent. Sa unenforceable contracts, both parties or all the parties cannot give consent. So magiging unenforceable contracts yun. So that's the distinction of an unenforceable contract. Hindi siya ma-enforce because of that certain defect. Ngayon, talking about this one, connecting it to the topic of form of contracts, isa sa mga nagbibigay ng defectiveness sa contract that would result it to be unenforceable is the non-compliance with the provided statute of frauds. The non-compliance with the provided statute of frauds by law. Kapag hindi mo sinunod yung requirements ng statute of frauds, aba Diyos ko kapatid, unenforceable yan. Though it is valid, there's no question about that. However, useless rin. Bakit? It is unenforceable. You cannot enforce it. Diba? Anong useless ng agreements nyo? Anong useless ng judgment? If it is not enforceable, if it cannot be executed. Diba? An example. Cannot execute. Example, yung Hague ruling for the Philippines. Diba? No matter how you put it, no matter how you say it, the fact remains that it cannot be enforced because the International Criminal Court, the International Courts, isa sa mga notes niya o sa mga rules niya is that rulings can only be executed, can only be enforceable when both of the parties agreed for it to be executed. Yung Hague ruling, it was not ratified, it was not agreed upon. China was not even part of the legal proceedings. So, yan? Unenforceable. So, mga ganong klaseng bagay yan, kapatid. So, yan yung problema. Yes, it is valid. Walang question dun. Pero, it is unenforceable. And gaya na sabi, punta dun sa topic na yun, unenforceable kasi isa sa mga nagbibigay ng defect, nagbibigay ng unenforceability sa contract is yung non-compliance with the statute of frauds. Ang statute of frauds kasi, basically, it is a requirement provided na kung saan, in layman's term or in simple explanation, nagpo-provide to ng requirements para certain transactions, certain agreements must be in writing in order to prevent fraud. Kaya nga statute of frauds. So, not only to prevent fraud but also to guard against the mistake of honest men by requiring that certain agreements be specified. Kung saan itong mga agreements na to are susceptible to fraud. So in order to avoid that or minimize or mitigate the effect, isulat mo. Mitigate to fraud, makaiwas ka sa fraud, isulat mo para klaro. Para klaro, eto. Yeah? May present ka, may evidence ka. Diba? Kung magbibigay ka ng assertion, at the very least, you must have an evidence to provide shots. Because in our legal system, the one who made the assertion has the burden of proof. Kung ikaw ang nag-akusa, the burden of proof is on your side. It's your obligation to do. Hindi mo ipapasa yan sa defense na kailangan niya patunayan na innocent. Hindi. Kailangan mo patunayan na guilty siya. Ang required niya lang minimum gawin, i-invalidate yung assertions mo, yung mga evidences mo. Yun lang kailangan niya. Kasi the burden of proof is on your side because you're the one who made the assertion. Hence, kailangan ng statute of frauds in order to protect people from fraud. So, kaya ang sinasabi dito, when the contract which by its nature requires the compliance ng statute of frauds, ng requirements sa statute of frauds, yeah? Tapos hindi mo kinomply, wala. Consider yan as an unenforceable contract, which will be discussed in depth next lecture video. Kasi doon pa yung defective contracts, kapatid. So, basahin natin. In cases of contracts by statute of frauds, the law requires that they be in writing subscribed by the party, charged or by his agent. If the contract is in writing, the contract is still valid. Assuming na yung essential elements are present, of course. But it cannot be proved and therefore it cannot be enforced unless it is ratified, unless it is cured. Inayos mo yung defect. So yan yung unenforceable contracts are discussed in chapter 8. Next lecture video pa yon. So yan na. Ito, unenforceability yan. Valid or enforceability. Yung pangatlo naman is the convenience portion. Convenience portion. So Article 1357 provides that if the law requires a document or other special form as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form. Once the contract has been perfected, this right may be exercised simultaneously with the action upon the contract. So ito. Yeah, form of the contract for the convenience of the parties. Now, there are certain cases kasi There are certain cases kasi na tawag dito, na medyo hassle kapag kulang ka ng documentary evidences. But take note, we're not talking about validity here kasi natapos na tayo dyan. We're not talking about enforceability here kasi natapos tayo dyan. We're talking about convenience here. Kung saan, obviously, by saying that, the contract we're talking about from this 1357, they're valid. They are enforceable. There's no question about that. However, there are certain caveats. There's certain hassleness, kumbaga. Kasi tingnan mo, kung binasa nyo to, of course, dapat basa muna kayo before nag-lecture video. Bigyan nyo panoorin tong lecture video. Pag kulang ka kasi ng documents, ng forms, mahirapan kang i-register yan sa property registry. Mahirapan kang i-compel yung third persons na i-follow yung contract na yan. Hindi yan enforceable sa kanila eh. Bakit? Baka kasi hindi siya public instrument. Tandaan nyo, pag ang isang document naging public document, nagpa-notarize ka sa abogado, so public document na yan. Public document na yan. The thing kasi about bringing it or making it a public document is that you are notifying the public that this certain transaction, that this certain contract, that this certain agreement exists. It's all about notification, kapatid. So kapag hindi mo ginawang public document yan, hindi mo pinanotarize, tigas ng ulo mo, kawawa ka. Kasi hindi yan enforceable to third person. Though it is enforceable between the parties, yes, it is enforceable between the parties. The parties themselves can even compel each other to properly comply with the forms. They can compel each other. They can go to court. Kung matigas ang ulo, they can go to court to compel each other para or pala i-follow yung form ng contract para maging convenient. They can do that. However, the problem is, until such be done, hassle yan sa kanila. Hindi yan enforceable sa third parties. So, pa yung third parties, naging affected sila dyan, tapos in their defense, they can say na, di naman yung public document yung document nyo dyan Di naman public instrument yung ginawa nyo dyan Because of that, I was not notified. Because that is the purpose of making it public to notify third person so that it can be enforceable against them. In that case, inconvenient yun sa'yo. So, para maging convenient sa'yo, follow the certain forms na lang. Para kahit yung third parties na epal dyan sa agreement nyo, masabi nyo, Public document to, assume, notified ka dito kasi it is enforceable to third persons na, public document to. Di ba? Convenient. So, ito may examples tayo dito. Basahin nyo na lang. So, 1358 tayo. The following must appear in a public document. Acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real properties or real property or an interest therein are governed by Articles 1402, number 2, and 1405. So, itong 1403, number 2, and 1405 sa unenforceable contracts yan. Number 2, the cession, repudiation, and renunciation of hereditary rights or of those of the conjugal partnership of gains. Pangatlo, the power to administer property or any other power which has for its object an act appearing on which should appear in the public document or should prejudice a third person or prejudice. Mas bet ko prejudice. Mas maganda siyang pakinggan. Prejudice a third person. The cession of actions or rights proceeding from an act appearing in a public document. All other contracts where the amount involved exceeds 500 pesos must appear in a public, must appear in writing, even a private one. But sales of goods, chattels, or things in action are governed by Article 1402, number 2, and 1. So, statute of frauds into unenforceable contracts. So, ang pinag-usapan dito kay Article 1458, the contracts covered by this article are valid and enforceable, though not contained in public document or instrument. Valid, basa nyo, valid and enforceable. So, hindi siya ito, ito siya, nandito yan siya. However, the public document is required only for the convenience of the parties and greater protection of the parties and to make the contract binding against third person, because making it a public document, ulitin natin para ma-instill to sa utak nyo, making it a public document would entail that the public is notified about this certain transaction, about this certain agreement, in order for them to be informed, in order for them, di ba, para maging enforceable yan sa kanila. Yan yung kahalagahan ng pagiging public document yan. So kayo, for your own convenience sa future, pasok kayo sa mga ganyang contracts, public document, kapatid. Para pag may umepal na third person, pakita nyo lang, poop, public document to. Wala kang magagawa. You are notified because this is a public document. So yan lang. In other words, the law does not require accomplishment of certain acts or contracts in a public instrument in order for it to be valid and enforceable, but to ensure its efficacy so that after the existence of the act or the contract has been admitted, the party bound may be ordered by the court in which the action or suit is filed to execute the document. So yan, ilang pages na lang, 30 minutes almost 30 minutes discussion. Pero ang kalagan dyan, mapasok to sa utak nyo. So to, next chapter tayo. Okay, dito tayo ngayon sa chapter 4, Reformation of Instrument. Reformation of Instrument. So 1359 provides that when there have having been a meeting of minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement. By reason of misstatement, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument to the end that knows that such true intention nila may be properly expressed. If mistake, fraud, inequitable conduct, or accident has prevented a meeting of minds of the parties, the proper remedy is not reformation, but rather, not reformation of the instrument, but rather its annulment. The annulment of the contract. So ano nga ba itong reformation, kapatid? Reformation is the remedy provided by law. Kung saan, a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties. When by reason of mistake, fraud, or inequitable conduct or accident, the instrument fails to express such agreement or intention. So basically ano yan? Ito kontrata nyo. Tapos yung ginagawa niyo yung kontrata nyo, may mga certain provisions na medyo hindi nyo na napag-usapan nyo. So in that case, anong gagawin nyo? Gawa kayo bagong kontrata kung saan yung mga provisions na not reflecting the agreement you made, di ba? Not reflecting the agreement you made, ayusin nyo sa newly reformed contract. But take note of this. As provided in the second paragraph, if mistake, fraud, inequitable conduct, or accident has prevented a meeting of minds of the parties, di ba? The proper remedy, not reformation, but rather annulment. Di ba? Now, what's the reason for reformation? Equity orders the reformation of an instrument in order that the intention, the true intention, yung kung ano talaga yung pinag-usapan nila, di ba? Kung ano talaga yung napag-usapan nila, na kung saan hindi properly na-reflect sa kanilang contract, sa kanilang written agreement, ayusin. Kagawa ng bago, i-reform, kumbaga, yeah? I-reform para sa reform contract, eto, ma-reflect na yung tama, yung kung ano yung gusto nila, kung ano yung napag-usapan nila. Ganun lang yung kasimple. Ang reason for that is, hindi mo pwede compel, hindi mo pwede enforce yung isang bagay na hindi naman pala yun na nag-agree siya, di ba? The rationale of the doctrine is that it would be unjust and inequitable to allow the enforcement of a written instrument which does not reflect the true intention, which does not reflect or disclose the real meeting of the minds of the parties. Yeah? So itong kahalagahan dito, binibigyan kayo ng chance na ayusin. Para kung ano yung true intention nyo, yun yung masusunod. Hindi kung ano yung nagkamali dito. Ito dapat. Yeah? So anong requisites for reformation? Una, there must be a meeting of minds of the parties. There must be a meeting of minds. Oo. Like, ito yung pag-usapan nyo, nag-agree talaga kayo. Kaso may mga defect lang talaga na hindi nag-reflect o hindi na-reflect yung true intention nyo. So, ang problema kasi pag wala yung meeting of minds, then there's no reformation to be talked about because there's no agreement. Hindi kayo nag-meet sa gitna. Oo. There's no agreement. There's no consent given in that case. Diba? Ang iniisip mo, ito. Ang iniisip mo, number 1. Ang iniisip niya, number 2. There's no agreement in that. Yeah? There's no meeting of minds. Dapat pareho kayong number 1. Ang nangyari lang talaga, ang nasurat, letter L, small letter L, yeah? Lowercase l. Dapat ang agreement nyo is 1. Ang nasulat lang is small letter l. So, in the Reformation, lalagay nyo, klaro, number 1. Yeah? Simple lang yan. Simple illustration lang. Yeah? Kasi pag walang meeting of the minds, ulitin natin para mas maintindihan. Dapat may meeting of the minds. Ang inisip nyo, ang nag-agree kayo dalawa, di ba? Number 1. Ang nagka-problema lang, yung nasulat is letter L, lowercase. So, since mayroon naman kayong agreement, nag-meeting of the minds lang kayo, hindi lang talaga na-reflect yung true intention nyo sa contract, okay, reformation, ayusin nyo, gawin yung number 1. Yung klarong number 1. Yan, may meeting of the minds yan. On the other hand, kapag walang meeting of the minds yan, ang iniisip mo, number 2, ang gusto niya, number 1, wala. Walang consent dyan, walang mabibigay na consent dyan, walang meeting of the minds yan. Because, ano ang contract? A contract is a meeting of minds between two persons whereby one bounds himself with respect to another to give something or to render some service. Walang meeting of the minds yan, so hindi nyo makakonsider as, hindi nyo magagamit yung remedy of reformation. Magagamit nyo lang dyan is annulment. Yung second requisite, the written instrument does not express the true agreement or intention of the parties. Di ba? Number 1 yung iniisip nyo, letter L yung nasulat, lowercase. Not reflecting the true agreement, which is number 1. Simple illustration lang para mas madali. Number 3, the failure to express the true intention is due to mistake, fraud, inequitable conduct, any act or omission which is unjust or unfair, or accident. In this case, mistake. Di ba? Mistake. Kasi alam natin, di ba? Minsan, maraming tao. Ang pagsulat ng number 1 is like this. Diba? Meron din, number ito, meron, ganito lang. Ngayon, tip lang, pagdating sa mga formal documents, pagdating sa mga formal documents, ito ang gamitin nyo, yung klarong 1, wag ito, mahirap, para less hassle sa future. Mahirap na pag itong gamitin nyo, mga ganito or ganito, yung klarong 1. Pag sa future, yan ang gawin nyo sa mga formal documents para convenient on your part. Pangatlo, or pangapat, the facts upon which relief by way of reformation of the instrument is sought are put in issue by the pleading. So, more on courting judicial process. And number 5, there is clear and convincing evidence, which is more than mere preponderance of evidence. So, yung degree of being clear, mas mataas sa preponderance. Diba, as we have said, pagdating sa civil stuffs, so civil suits, civil cases, yung evidence na kailangang i-present is mere preponderance lang. Pagdating sa criminal stuffs, criminal cases, beyond reasonable daw. Mas mataas yung degree of believability. Mas mataas yung degree of proof. Itong clear and convincing evidence, so sa gitna nilang dalawa. There is a clear and convincing evidence of the mistake, fraud, inequitable conduct, or accident. So ito, another topic is reformation, distinguished from annulment. Magkaiba yan sila. Because sa reformation, as we have said, ito yung pag-usapan natin sa number 1 and L, meron agreement, merong meeting of the minds. Sa annulment, walang meeting of minds yan. The consent of one of the parties being vitiated by mistake, etc. Yung VIMFU. Yeah. Ganyan kasimple. So, ito example. Sold this land to be. Sold this land to be. To be is all I gotta be. Maraming tutubi sa tabi-tabi. It was agreed that the sale will include all the improvements. Yeah. However, the contract as signed by the party states that the land is being sold excluding the improvements thereon. In this case, the remedy is reformation. The remedy is reformation because there has been a meeting of minds of the parties. Kasi di ba ang usapan nila, si S magbebenta ng land kay B kung saan sa land with improvements to siya. Yan yung napag-usapan nila. However, sa contract, land lang ang nakalagay. Land lang. Hindi kasama yung improvements. Diba? Excluding improvements sa kalagay. So in this case, may meeting of the minds. Klaro yung napag-usapan nila. Kaso hindi lang na-reflect sa kanilang kontrata. Land lang, excluding the improvements. Diba? In that case, reformation. Lagay nyo, palitan nyo land, including improvements sa reform contract. Okay, goods. It reflected the true intention of the parties. However, on the other hand, itong sa second paragraph, if S was selling the land to B, to B, excluding the improvements. Sa kanya, excluding, without the improvements. Kay B, ang inisip niya, with improvements. Yeah? In that case, there has been no meeting of the minds kasi, gaya na example natin kanina, si S inisip niya number 1, si B inisip niya number 2. Hindi sila nag-meet. Hindi pareho yung kanilang intention, so there's no meeting of the minds. So in that case, yung contract na na-form nila, annulment ang remedy. Di ba? Mahalaga yan, meeting of the minds, di ba? Kasi meeting of the minds, ito yung napag-usapan natin. Problema lang, hindi properly na-reflect sa contract. So hindi properly na-reflect sa contract, anong gagawin mo? Di-reform mo lang yung contract para goods na. Ganun lang yung kadali. So 1360. The principles of the general law of the reformation of instrument are hereby adopted insofar as not in conflict with the provisions of this code. So simple lang yan kay na 1360, Civil Code, when it comes to reformation, general law. Ganyan kasi pagdating sa mga batas nating kapatid. Special law, when it comes to parang sa accounting standard yan. Yung general, not necessarily, na kapag parang sa accounting standard yan, di ba? Yung conceptual framework, under sa specific standard. Kasi yung yung particular standard na yan, it has provided a more specific, a more particular, a more specialized discussion on the standard, on the accounting standard, on the transaction. Hence, it is properly followed, di ba? Or hence, it has the mas nakakaangat siya. Mas nakakaangat siya. Di ba? Pag may conflict, si standard ang fina-follow. Kasi nga, si standard provides a more specific detailed, more specific, more detailed discussion on the standard. Same dito. Itong sa sa legal system natin. Special law, general law. Mas nakakaangat or erase natin para mas ma-reflect. General law, pag may conflict sa dalawa, mas mananaig si special law. Bakit? Kasi si special law nag-provide ng more specific, more detailed, more detailed thingy, more detailed discussion, more detailed enforceability pagdating sa certain transaction na yan. In this case, when it comes to reformation, civil code shall prevail over the general law on reformation. The general law will act like supplementary lang, taga-support lang. 1361, when a mutual mistake of the parties causes the failure of the instrument to disclose the real agreement, said instrument may be reformed. Ito, mutual mistake o mistake of fact on both of the parties of the instrument which causes the failure of the instrument. Mutual mistake. Pwede nila ayusin. So, to justify reformation under this article, may requisites tayo. The mistake must be of fact, hindi law, hindi the mistake must be of fact, hindi must be of law, kasi pag must be of law yan, legality na yan. Pero to fact lang na iba lang yung nasabi nila. Iba lang yung nalagay nila. Such mistake must be proved by clear and convincing evidence. The mistake must be mutual, that is common to both parties of the instrument, and mistake must cause the failure of the instrument to express their true intention. Of course, ganyan pinag-usapan sa Reformation. Ito yung true intention, hindi lang na-reflect sa document. So, ayusin yung document, i-reform mo para ma-reflect yung true intention ng parties. Ganyan lang si Chapter 4. Ganyan lang kasimple. So, example. Ito dito, if the mutual mistake is of law, the remedy is annulment. Gaya na sabi natin, iba yan sa mistake of fact. Iba lang yung nalagay nyo na instead of 1, nalagay nyo 2. Instead of 2, nalagay nyo 1. Instead of 1, nalagay nyo lowercase l. Yun, mistake of fact lang yun. Pero pag napunta na kayo sa legality, napunta na kayo sa mistake of law, wala kayong choice. Hindi nyo pwedeng labagin yung batas. Hindi nyo pwedeng labagin yung batas. So, annulment na yan. So, to S and B entered into a contract whereby S sold to S his horse named Silver. So, yun, bentahan sila kabayo, Silver, pangalan. By mistake, the contract as written and signed by the parties states that the horse sold is golden. So, namali lang yung nalagay nila. Namali lang yung nalagay nila. Si Silver ang ibenta, si Golden ang nalagay sa kontrata. So, mistake yan. Reform. Tanggalin nyo si Golden, lagay nyo si Silver sa contract. Ganyan kasimple. Article 1362, if one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. So, sabi dito kay Article 1362, the right to ask for reformation is granted only to the party who has mistaken in good faith because they were in good faith. The one who committed fraud, bad faith. And sino lang binibigyan natin ng remedy? Sabi ng batas, yung inosenteng party. Kasi wala siyang ginawang kasalanan eh. Bakit mo sila ipaprevent to have a remedy? So sila lang. Kung sino yung good faith, yun. And tingnan nyo, balikan natin sa 1361, mutual mistake. Ibig sabihin good faith ang both parties. So pwede sila mutual mistake good faith yan. Innocent party, both of them innocent parties. Pero pagdating kay 1362, yung isa, mistake, yung isa, fraud. Fraud is bad faith. Fraud is, may malis ka dyan. May malis intention ka dyan. Si mistake, nagkamali ka lang. So, innocent party ka. So the right to ask for reformation is with the innocent party, the good faith dude, the mistake one. Now take note, di ba? Nasama dito yung salitang fraud. Balikan na natin ang pag-usapan natin, di ba? In regards to fraud. Kasi di ba? There are two types of fraud. Recap lang. There are two types of fraud. Fraud in the performance of the obligation. Yeah. Fraud. Recap lang kasi may connection to dito eh. Fraud in the performance of the obligation, performance of the obligation, and fraud in regards to consent. Ba? Consent. Yeah? Fraud in the performance of the obligation and fraud in the performance of the consent. In relation to the consent. Ngayon, di ba sa consent, dalawa yan. Ano yung silang dalawa? Pinalala nyo pa? Si dolo causante and si dolo incidente. Si dolo causante, ito yung klase ng fraud. Recap lang natin kasi connected to dito eh. Si dolo causante, ito yung klase ng fraud na kung saan, because of the commission of this fraud, the consent was obtained. The consent was obtained. Now, in that case, the contract is voidable. Yeah, the contract is voidable. Ano naman si dolo incidente or si incidental fraud? Dito naman si dolo incidente, si incidental fraud. Whether or not such fraud was committed, the consent will still be given. Yeah? The consent will still be given. It does not matter if that dolo incident was committed because the innocent party, the good faith dude, will still give his consent. Kasi hindi relevant yung pagbigay niya ng consent sa fraud na to. Yan yung difference nila. Dolo causante, ito yung naging reason kaya binigay yung consent. Dolo incidente does not matter because the consent, whether or not na-commit yung dolo incidente, yung fraud, yung incidental fraud, the consent will still be given. Goods lang. So in this case, pinag-usapan natin sa 1362, anong dolo yan? Anong fraud yan? Dolo incidente. Kasi kapag dolo causante yan, there's no meeting of minds. O, di ba? There's no meeting of minds pag dolo causante yan. Pero ito, there's meeting of minds. So, reformation. Dolo incidente lang yan. Because, sabi natin sa dolo incidente, recap, repetition is the key. Whether or not such fraud was committed doesn't matter because the consent at the end of the day would still be given. Connection yan sila. Article 1363. When one party was mistaken and the other knew or believed that the instrument did not state the real agreement but concealed that fact from the former, the instrument may still be reformed. But take note, si good faith party, si innocent party, yung mistake lang, siya lang yung pwedeng ask for remedial reform. Siya lang yung pwedeng mag-avail niyan because he acted in good faith. Oh, the concealment mistake by the other party constitutes fraud. 1364. So, bad faith siya. Hindi pwede. 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or of the clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. Obviously, understandable naman. 1365. If two parties agreed upon mortgage or pledge of real property, of real personal property, kasi mortgage sa real personal property pledge. Etong pledge or mortgage ng real personal property, loan, ano yan? Third year, second year nyo, second sem. Law on sales, carry transactions, etc. Diyan yung di-discuss yan. Kasi sa second year nyo, first sem, loan partnerships, business law and regulations yan, loan partnerships, loan corporations and cooperatives. So, if two parties agree upon the mortgage or pledge of real property or real personal property, but the instrument states that the property is sold absolutely or with the right of repurchase, reformation of the instrument is proper. Obviously, understandable naman. So, 1366 tayo. There shall be no reformation in the following. So, bawal tong reformation daw sa following cases. Simple donation inter vivos wherein condition is imposed, wherein no condition is imposed. Sorry for that. Pangalawa, wills. Dito si Willie Villamin, wills. Yung pag namatay ka, may will ka. Tawag mo sa Tagalog, nakalimutan ko. Ano ba so? Will. Anong tawag sa Tagalog ng will? Nakalimutan ko. Basta will. Pag namatay ka, doon mo nilagay kung sinong anong ipapamana mo. And when the real agreement is void. So, naman 1367, when one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. So, ito, cases when reformation not allowed. May 4 na cases tayo as provided by 1366 and 1367. Yung una, simple donations inter vivos, where no condition is imposed. Ngayon, ano mean itong inter vivos? Inter vivos mean lang yan, habang buhay ka pa. Habang buhay ka pa. Kasi, pag yung donation mortis causa, yung opposite niya, those are donations made in contemplation of death. Meaning, na-feel mo na, malapit ka na mamatay, so din nag-donate ka na. Nag-donate ka. Yun. Those are donation mortis causa. Donation in contemplation of death. Inaabangan mo nang mamamatay ka, so nag-donate ka na. Dinonate mo na yung mga properties. So, yung donation inter vivos, habang buhay ka pa, walang death na nakano dyan. So, in this case, bakit hindi pwede reformation dito? Simple donations under inter vivos wherein no condition is imposed. Bakit? Kasi ang donation, kapatid, this is an act of liberality on the donor. Out of his own kabaitan, kaya siya nag-donate. Kaya siya nag-donate with no conditions imposed. Tandaan nyo, emphasis on the no condition imposed. Basta ka lang nag-donate. Ngayon, nag-donate ka. Ito naman si Donnie, sabi mo, itong ibibigay mo sa akin. Aba, choosy kang loko ka. Nag-donate na nga sa'yo. Demanding ka pa. Gagawin na sa pagka-entitled mo. Hindi mo, si Donnie, he cannot compel the donor to reform the donation. If the donation is kung saan, emphasis, walang condition. Because the act of donation is an act of liberality on the part of the donor. Nagbigay na nga, gabi naman, aabusuhin mo. Diba? So, bawal ang reformation dyan. But take note, that is only applicable, emphasis ulit, kapag walang condition. So, kapag may condition yan, or it is onerous in character, pwede ma-reform so that the true conditions imposed by the donor or the real intention of the parties might be expressed. Diba? Second, sa wills, same reason sa donation. It is an act of liberality on the part of the dead person. Before pa siya namatay, na ng kanyang properties, distribute. So in that case, hindi mo pwedeng, magbibigay na ngayon tao, gagaguhin mo pa. Di ba parang ganun? Act of liberality yan. Nagdo-donate na nga, bakit mo gaganunin pa? Gabi ng pagka-entitled mo. Yeah? Gahaman na yun. Third, when the real agreement is void. So, pag yung real agreement, kapag yung source is void, yung effect void rin. Ganyan kasimple yan. And third, when one party has brought an action to enforce the instrument. Di ba? Ano to? Basically, meron kang, may agreement kayo. Which, does not reflect the true intention of the parties, though there's a meeting of mind, pero it does not reflect the true intention of the parties. Ngayon, yun, di ba? Yun ang agreement mo. Parties A and B. Ngayon, alam mong ganun na it was not properly reflecting your true agreement. Yeah? Alam ni A, alam ni B, na the contract is not reflecting their true agreement, though there's a meeting of mind between the two of them. Kaso itong si A, nakita niya, mas maganda man tong contract natin. In-enforce niya. Pina-enforce niya. When one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. Because he already by asking, by filing an action to enforce the instrument, di ba? Si A, yun ang ginawa, A admits validity and that it expresses the true intention of the parties. So, the bringing of the action is thus inconsistent with Reformation. So, 1368, Reformation may be ordered at the instance of either parties or successors in interest if the mistake was mutual. Otherwise, upon petition of the injured party or his heirs and assigns, the 1369, the procedure for the reformation of instruments shall be governed by the rules of court so promulgated by the Supreme Court. Okay, yan lang. Yan ang discussion natin for Chapter 4. Chapter 5 tayo next. So, dito tayo sa Chapter 5. So, itong Chapter 5, Interpretation of Contracts. Madali na lang to. Kahit basahin na lang ito, madali naman siya intindihan. Kasi ang basis lang naman, ang punto lang naman ng Chapter 5 is kung ano yung nagre-reflect ng true agreements ng party, kung ano yung mas sensible interpretation ng contract, yun yung mananaig. Ganun lang kasimple si Chapter 5. So, 1370, if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, meaning klarong-klaro yung contract, yeah? Hindi questionable. The literal meaning of its stipulation shall control. So, yun yung mananaig. Ngayon, if the words appear to be contrary to the evident intention, yung klarong intention ng parties, diba? The latter shall prevail. Meaning, words ng contract, mas mananaig yung intention. So, yun lang sa, di ba? Sa Reformation, pinag-usapan sa Reformation, mas mananaig ang intention ng parties more than sa kung ano yung nakalagay na wording sa contract. Intention ng mananaig. Kasi nga, meeting of minds, kapatid. Yeah? So, interpretation of a contract is the determination of the meaning of the terms or words used by the contracting parties in their agreement. So, pinag-usapan lang dito si Chapter 5. Parang supplementary lang to. Parang supporting provisions to si Chapter 5 na kung saan, pag medyo may problema sa interpretation ng contract, medyo may problema sa wording ng contract, yeah? Okay, ganito natin yan ayusin. So, supporting yan si Chapter 5. Di gaya ng shota mo, hindi supportive sa'yo. So, contracts, private laws, the parties bound by such term. So, let's go to... So, evident intentions of parties prevails over terms of the contract. Of course, kasi, meeting of minds, kapatid, hindi mo sila pwedeng ipilit sa hindi nila, sa isang bagay na hindi sila nag-agree. Yeah? Which is the wording of the contract na medyo iba. So, yung true intention sila, yung mananaig. Ito mga example, S sold his parcel of land to B. Kung saan, agricultural to. Ngayon, it is not disputed that the reasonable value of the land is 50,000 pesos. However, the contract of sale states that the purchase price is 500,000 peso. So, nasobrahan ng zero yung nakalagay sa contract. Instead of 50K, 500K. Ngayon, so anong mananaig? Yung 500K, yung 50K. E di yung 50K kasi yung pinag-usapan. Diba? So, reformation yan sila dyan. Yeah? So, connected yan yung mga topics ito. Ito naman, si R nag-enter ng contract of lease kay E. Kung saan si R, ililis yung kotse ni E. So yan, contract of lease yung nila. Yung pinag-usapan nila. Yeah? However, ito yung stipulation. Si E, magbabayad ng 100,000 pesos upon signing the contract and additional 5,000 pesos by way of rental daw on or before the 5th day of every month. So every month, di ba? And at the end of 1 year, E would become the absolute owner of the car. The contract fixed the value of the car to be 160,000 pesos. So, parang may mali. Contract of lease, di ba? Renta-renta yan. Lease. Bakit nagkaroon ng ownership at the end? So, para siyang contract of sale. Yung 100,000 pesos, di ba? Parang down payment lang yan. Then, yung 5,000 per month, di ba? Para siyang additional installment payment. Nagbayad kang down payment, yung natitira, installment na lang. So, by its true nature, although it is labeled as contract of lease, it is a contract of sale. Because that was the intention of the parties. Yeah? In order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. So, paano sila nag-act? Yeah? Paano yung galawan nila? Paano yung usapan nila? Subsequent and contemporaneous act, what is happening right now. Subsequent act, what happened after the perfection of the contract. And not only those, pati yung antecedent act, yung before the contract was perfected during the negotiation portion, yeah, it will be taken into consideration kung saan yung interpretation doon para malaman kung ano yung totoong intention ng parties. 1372, however, general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. So ito, as a rule, where in contract, there are general and special provisions, yung mananaig, yeah, over the subject matter will be the special provisions because special provisions has provided a more specific, a more detailed explanation on the subject matter. So it will provide a better interpretation. Hence, it will provide a better showing kung ano yung true intention ng parties. Kasi hindi ka maglalaan ng oras para sa special provision na yan kung hindi yan yung napag-usapan nyo. Kung hindi yan yung pinag-agree nyo. Di ba? Simple. So, S sold this house including all the furnitures therein. The term all, including all the furnitures, the term all should not be understood to include S refrigerator, which is distinct and different from being called a furniture. It is an appliance, di ba? Neither should it be interpreted to include chairs borrowed by S from C for the reason that they do not belong to S. Yeah? Mga ganong interpretation. 1373. If some stipulation of any contract should admit of several meanings, it shall be understood as bearing the import which is most adequate to render it effectual. So, ano agreement ito? When an agreement is susceptible of several meanings, several interpretations, paano yan? Magulo yan. Yeah, magulo yan. So, paano yan? Hanapin mo yung meaning. Hanapin mo yung meaning. Hanapin mo yung interpretation which would render it effective, maayos. Di ba? It should be given that interpretation. Thus, if one interpretation makes a contract valid and the other makes it illegal, siyempre, anong pipiliin mo? Mahal mo o mahal ka? Hindi. Yung illegal na interpretation o yung valid na interpretation? Yeah? Yung valid. The former interpretation, so no warranted by rules, So S sold this parcel of land to B. Now S has two lands. One owned by him and kung saan, absolutely owned by him. Wala siyang co-owner. And the other land na kung saan, co-owner niya si C. Si C did not give the consent to the sale. So, dalawang parcel of lands. Dalawang parcel of land. Yung isa, absolute ownership. Yung isa, co-owner si Co-owner si C. So, alin yung ibebenta niya? Di yung absolute ownership. Kasi hindi niya pwedeng ibenta to kasi hindi binigay ni C yung kanyang consent. So, that would be legal. So, yung S, yung S, yung absolute, yung land na may absolute ownership siya. Ganong interpretation. Yung maayos, yung pwede mong ma-enforce ng maayos. 1374. The various stipulations of a contract shall be interpreted together, attributed to the doubtful ones, that sense which may result from all of them taken jointly. So, ito yung mga klase, di ba? Problema sa mga tao, when they see contracts, hanapan nila ng butas. Ang problema, paghahanap nila ng butas, yung mangyayari dyan, they will cherry pick, pipiliin lang nila kung ano yung hindi maganda. Ang problema dyan, you should take the document, you should take the contract at its whole. Hindi yung mag-cherry pick ka lang kung ano yung ano yung mag-justify ng narrative na gusto mong sabihin, di ba? Parang ginagawa sa political, di ba? Titingnan lang yan nila kung anong mga details ang, although true, pero mag-cherry pick din, pipiliin lang nila kung ano yung mga details that would justify, that would further their narrative. Mga ganong klaseng shenanigans. But in this case, pinag-usapan natin dito sa contract, wag ganun kapatid. Take the contract as a whole. Wag lang mag-cherry pick. Oo, kasi loko ka. You're furthering a narrative that is not true. Because you should take the entire document in its entirety. So, 1375, words which may have different signification shall be understood in that which is most in keeping with the nature and object of the contract. Mga dadaling interpretation lang to. Parang samahan mo lang ng common sense, samahan mo lang ng true intentions ng parties. Kung ano yung sensible, Eh di yun yung proper interpretation. Eh di yun yung dapat gawin. Di yun dapat i-follow. Ganyan lang si chapter 5. So, interpretation of words with different significations. So, basa-basa na lang. Dahil naman kasi to. The usage or custom of the place, 1376. The usage or custom of the place shall be borne in mind. Shall be borne in mind in the interpretation and of ambiguities of the ambiguities of a contract, and shall fill the omission of stipulations which are ordinarily established. So, yung pag may mga certain kulang or may mga malalabong provisions, stipulations sa contracts, or may mga kulang na provisions, then take into consideration yung usage or custom kung saan na perfect yung contract. Kung ano yung ginagawa nila doon, okay, take that into consideration. Kasi ang common sense will tell you that when the parties in that area created that contract, they took into consideration kung ano yung nangyayari sa lugar nila. So in that case, you can use the customs, you can use the usage in that place to further, to make it clearer, the interpretation of the contract. Yeah. So, the interpretation at Article 1377, may examples naman dito. Basahin niyo lang. The interpretation of obscured, malabong words, or stipulations in contract shall not favor the party who caused the obscurity. So, yung mga, may mga certain contracts kasi, na kung saan, yung written agreements yan, usually, yung isang party yung gagawa niyan, mag-agree na lang yung other party. So, yung gumawa ng agreement, yung nagsulat, yung nag-type, yung nag-print, kapag merong obscurity, kapag merong malabong provisions yan, it will be it shall not favor the party who caused the obscurity. Kung sino yung nagsulat ng kontrata, sino yung nag-type, nag-print. Bakit? Chicken, ikaw ang gumawa ng kontrata, bakit may obscurity dyan? Aba, loko ka? Bakit hindi mo ni-make sure na properly yan, di ba? Ikaw ang gumawa ng kontrata, itinipe mo yan eh. Yeah? Parang ganung interpretation. A very good example of this is contract of adhesion. Contract of adhesion, meaning, ito yung mga klase ng kontrata na prepared na, may proforma na. Oo, i-print na lang, isa-sign na lang, itatype na lang yung pangalan ng other party. Yan yung mga bank loans. Yung mga bank loans, yun. Ready na contract yan, ready-made na lang, print na lang. Dagdagan na lang mga additional details. Insurance contracts. Ready na yan, ready na yan. To be printed na lang. Ayusin na lang yung ibang details. Contract of adhesion. Prepared na yan ng mga bangko. Prepared na yan ng mga ng mga insurance. Yeah? Yung mga plane tickets, contracts between lawyer and client. Ready na yung mga contract, ready-made na. Print na lang. With the changes of some details. Pangalan ng ng customer, ng client. So, yung mga klase ng contracts na, pag may mali dyan, edi yung insurance, edi yung bangko, yung may kasalanan. Kasi ginawa nila yan eh. So, ganyan yung sense niyan. 1378, when it is absolutely impossible to settle doubts by the rules established in the preceding article. So, sabi ito, kapag daw yung mga preceding articles na pinag-usapan natin, sina 1370, sina 1371, sina 1372, sina 1373, 74, 75, 76, 77, kapag hindi daw sila enough, mahirap kapag hindi ka enough. Pag hindi daw sila enough, to settle the doubts, and the doubts refer to the incidental circumstances of a gratuitous contract. The least transmission of rights and interest shall prevail. Kapag naman yung contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interest. If the doubts are cast upon the principal object of the contract, which, in such a way that it cannot be known, what may have been the intention of the will of parties, the contract shall be null and void. So, ito yung klase ng interpretation kung saan yung preceding articles, as we have said, hindi enough to settle the doubts. Hindi enough to settle the doubts. Ano kaya feeling na maging enough, no? So, in that case, paano? May tatlong instances, sa gratuitous, sa onerous, and yung sa principal object of the contract. Sa gratuitous, as we have said, di ba? Action of liberality to. Mabait ka dito. Nagbigay ka without any kapalit. So if the doubts refer to incidental circumstances of a gratuitous contract, such interpretation should be made which resulted in the least transmission of rights and interest. Bakit? In this case kasi nagbigay ka nang wala kang hinihinging kapalit. Wala kang hinihinging kapalit. Yeah? Wala kang hinihinging kapalit. So in that case, para hindi ka maabuso, yung interpretation that would result in a least transmission of rights and interest, yun yung gagamitin. Because, why? Para hindi ka maabuso. Kasi, ako liberality to eh. Naging mabait ka, nagbigay ka ng walang kapalit. Example, R gave his car to E. It is not clear whether the contract is a donation or comodatum. So, may dalawang interpretation dito. Binigay lang yung kotse kay E. Walang hininging kapalit, walang hininging bayad. Yeah? So in that case, anong contract to? Dalawang meron. Contract of comodatum, yeah? Or a contract of loan, pinahiram lang, comodatum, or a contract of donation. O, tingnan natin. Pag donation yan kapatid, there's transfer of ownership. Pag donation yan, there's transfer of ownership. Oh, anong interpretation yan? There's more transmission of rights and interest because donation, transfer of ownership yan. Pero kung comodatum lang yan, a contract of loan, pinahiram lang. Yeah? Pinahiram lang, pinaarkela lang without any payment. Yeah? Anong interpretation yan? Least transmissible. Least transmission of rights and interest. Kasi ito, pinahiram mo lang si comodatum. Pero yung donation, transfer of ownership na yan. So, alin sa kanilang dalawa? Alin kay comodatum? Alin kay donation yung may least transmission of rights and interest? Comodatum. So, in that case, it will be interpreted as a contract of comodatum. Pinahiram lang. Pinaloan lang. Pinahiram lang. Hindi binigay. Ganun. Onerous contract. If the contract in question is onerous, the doubt shall be settled in favor of the greatest reciprocity of interest. So, ibig sabihin yung magiging fair for both parties. Magiging fair sa kanilang dalawa. Yung interpretation na magpapakita na ito yung interpretation na mas fair or the fairest out of all the interpretation, then yun yung mananaig. Yun yung magiging pipiliin. Yato. D borrowed from C 5,000 pesos at 12% 12% interest. May problema. It cannot be determined from the terms of the contract whether the loan is payable in 6 months or in 1 year. So, paano to? Now, it must be assumed that the period agreed upon is 1 year. Bakit? Because this 1 year period results to a greater reciprocity of interest since kay D, yeah? Yung naghiram can use the money for 1 year. Hindi lang siya marirestrict sa 6 months, but rather 1 year. 1 year niyang, may 1 year siya para magbayad. Para kay C naman, on the other hand, C can earn interest due for 1 year instead of only 6 months. So, di ba? Yung 6 months, less time para makabayad si D, less interest income para kay C. Pero pag 1 year yung gagamitin, more time para makabayad si D, more interest income for C. Greatest reciprocity yun. So, yung 1 year yung pipiliin. And lastly, principal object of the contract. Now, if doubt refers to the principal object of the contract and such doubt cannot be resolved by leaving the intention of the parties unknown, the contract shall be null and void. Kasi of course, hindi klaro eh. So, that is walang meeting of minds. So, since walang meeting of minds, wala yan. Hindi yan considered valid. So, ito, S sold this land to B. Problema, S has many lands. Ang problema dito, hindi isinis-specify aling land. Yeah. Hindi ni-specify. So, it cannot be determined which land was intended by the parties to be the subject of sale. Take note, di ba? Yung pinag-usapan yung land dito. Yung pinag-usapan yung land dito, di ba? Yung land ni S, dalawa. Absolute ownership. And yung isa, co-owner si C. Binenta niya, nagbenta siya ng land. So, ang interpretation natin is yung land na may absolute ownership lang ni S, lang yung may-ari, yung ibebenta niya. Kasi hindi niya pwedeng ibenta to kung saan co-ownership yung land na kung saan co-ownership na si C. Kasi walang consentisi. So, ganyan. Maayos yung interpretation dyan, klaro. Ngayon, ang problema, ito, S sold this land to B. Nagbenta ng land kay B. Ang problema, maraming land si S. Mahirap ang interpretation, no? It cannot be determined which land was intended by the parties to be the subject of the sale. Kasi dito, di ba? Madali kasi, dito madali lang. Klaro. Dito hindi eh. Maraming land. So, alin dyan sa kanila? So, therefore, the contract shall be null and void, and it is as if the parties have not entered into any contract at all. Kasi ni klaro eh. Di ba? So, interpretation yan. Diba? Kita nyo ang difference. So, lastly, 1379, the principles of the interpretation stated in Rule 1, 2, 3 of the Rules of Court shall likewise be observed in the construction of contracts. So, Rules of Court na to, sa law school na to. Principles of interpretation of the Rules of Court. The Rules of Court on the interpretation of the documents are now contained in Rule 130, Section 8 to 17 thereof. So, yun ang discussion natin for this lecture video. Diba? Madali lang. Form of contract, reformation, and interpretation. So, with that, long quiz tayo sa Saturday. Topics, chapter 1 to 5. Tapos after no, next week, another lecture video, probably our last lecture video, most probably, defective contracts and yung natural obligations. So with that, end na ang ating lecture video. Goodbye. Love you.